I'm fine. Hello, everyone. I'm Helena Kennedy, and it's a great pleasure to be here. In fact, I was here when we had our original SLAP conference, I think. Was that last year? Or yes, was it last year? And so it's really very, very nice to be invited back. And let me tell you a little bit about myself. I'm a lawyer. I have been practicing at the bar. I'm actually this year celebrating 50 years of practicing at the bar. Now, I know that you're all looking at me and thinking, well, she doesn't look bad. She must be. And you're working out how old I am. And the other half of you are saying, well, she hasn't worn very well, really. Anyway, I've been practicing a very, very long time. And so I've had a lot of experience, one way or another, of the law, and particularly, and I've written extensively on the experience women have of the law courts, and I'm afraid it's very interesting. I originally wrote about the criminal justice system. And the experience women had there, both as victims and as defendants, and what happened, and as witnesses. But what happened then was that it sort of opened up a whole set of discussions that we had about other sections of the law, the way in which, for example, immigration law and asylum law did not take account of the particular and special ways in which oh, sorry, I thought that the room was so small you'd all be able to hear me buzzing in your ears. The other thing was that we then realised that asylum law had been built again around male experience, and so the ideas of persecution and what constituted persecution didn't apply to women, and slowly, bit by bit, we've been travelling the analysis of how the law fails women, because the law essentially has been made from a male perspective, has travelled to other parts of the law, and let me tell you, defamation and libel has still to be reached. And so to be asked today to be talking about the way in which SLAPs, the way in which, really the actions that can be taken against women in the defamation courts and in that arena pose very real problems too, and prevent the reporting of sexual harassment and sexual violation. I want to thank the organisers of the conference, Justice for Journalists Foundation and the Foreign Policy Centre. The International Bar Association's Human Rights Institute, which I'm the director of, has very good relations with you both, and we're really pleased to work with you, and we want to continue working closely with you as we go forward. At the Institute of Human Rights, which, as well as being a private practitioner as a barrister, I'm the director of the Institute of Human Rights there, the IBA, and we run a sort of high-level legal panel for the Media Freedom Project, which is an intergovernmental project that covers now 52 countries. But the high-level legal panel is really looking at the way in which the law fails in so many places. And so it's a great opportunity to work with journalists and others on these issues. I wanted just to talk about the ways in which the whole business of defamation, libel actions can actually affect women's attempts to get justice for wrongs that are committed against them, but particularly sexual violation. Although most related cases, cases related to SLAP, certainly here in the UK, have related to financial crimes and corruption, SLAPs have also been used in other areas, and we know that certainly in the UK and globally. And this panel today is going to be discussing one of those areas, which is the use of SLAPs in the cases that involve sexual harassment. And this impacts not only on journalists, but especially victims, leading to justice being delayed and denied over many times. Now, I know that you're going to be hearing from Harriet, who's going to be chairing the next session, Harriet Johnson, who's in my chambers. And I just wanted, before we go further, to say to you that Jeff Robertson, who's also in our chambers, Doughty Street, we all write books. That's one of the things that we spend time doing. And Jeffrey Robertson has written a book that's going to come out shortly about the ways in which the British libel laws, defamation laws, have to be reformed across the board, and how disgracefully they operate. Now, this panel that is going to follow my speaking to you will be discussing one of those areas, as I say, which is sexual harassment and its impact. Throughout my career, I've seen how women's experience of discrimination in the law really is still being dealt with in inadequate ways. And often the lawyering and the judging in these areas is unconscious. They don't even know that it's happening. But misogyny, and I want to emphasise this, I've just done a report in Scotland on misogyny. And misogyny is not simple hatred of women. It's a poor definition to see it in that way. Misogyny is about the continuing sense of male primacy and male entitlement. And so it's different. It's different from hating somebody because they're black. Almost every one of the men you will speak to who's a misogynist will say, I love women, I'm married to one. But what happens is that basically they have imbued this sense that somehow they're protected from the ways in which their behaviours can impact on women, and they have that sense of male entitlement. Me Too, and I wrote a book about this in 2018, has encouraged more and more victims, survivors of sexual harassment to speak out in public about the ways in which they've had terrible experiences, but how they've been failed by the law. For me, all that business of women going online and talking about what happened to them was really because law had failed women, and they had gone to employers, or they had gone to the police, or they'd gone to people who had some sort of authority about what had happened to them, but were not listened to. And their allegations were dismissed, their grievances thrown to one side. And so they were using social media as a way of really putting a brick through the windows of the criminal justice systems around the world. It was a form of civil disobedience. And so that movement has been met, of course, with responses. People, power is never ceded very easily. And so we've seen increased defamation lawsuits filed by individuals and companies with financial and legal resources as a means of silencing and discouraging victims and journalists from reporting on such cases. And in the United Kingdom, some of the claimant lawyers have been known to charge huge fees, which of course in turn then the lawyers for women who may have broken non-disclosure agreements or whatever, they know that if there's ends up being they lose a case, that there are risks associated with costs, and money is not something that women have in great quantities. So these suits and their costs, they take a long time to go through courts. There's also a sort of way in which often the other side deliberately ups the ante by having delays and so on, which of course add to the costs. And that's true for the experience of journalists who've been in these cases too. And the trauma of it is hard to explain to people, what the toll that it takes on people being involved in this kind of litigation. And I want to just mention some of the most notorious cases. Philip Green, some of you may remember Philip Green. He's the retail well, I better not be rude about him. In 2018, the Telegraph emailed Sir Philip Green, who owned Topshop, as you'll remember, notifying him that the paper would publish an article containing allegations of sexual harassment. And I mean, there were multiple allegations. There were 5 allegations from employees, and they'd all been subjected to non-disclosure agreements. I'm actually doing an inquiry just now into a similar sort of thing, but in a trade union. And I have to tell you, so these things are happening in many different places. Sir Philip Green had used the NDAs to silence and pay off the alleged victims. So when the Telegraph emailed him, Philip Green applied for an interim injunction through his lawyers to restrain disclosure of the information while the trial was pending. And he hired Schilling's law firm and a team of at least 7 lawyers to injunct the Telegraph. And originally the injunction application was rejected. However, Philip Green and Topshop appealed, and they were successful. And then it goes up to the Court of Appeal, and they reversed the original judge's decision, but they did impose an interim injunction to preserve confidentiality until the final judgment. And the case became notorious because of all the other notorious things associated with Philip Green. But a lot of what had taken place was kept under wraps because of the injunction. And it was only because Peter Hain, who's a colleague of mine on the Labour benches in the House of Lords, and who had been a cabinet minister and who was outraged by all of this, he used parliamentary privilege and got a lot of criticism for it, basically to reveal Green's identity and so on. As a result, Philip Green ended up dropping the injunction claim and was left with a £3 million legal bill. But it's a story that's worth remembering because it is absolutely classic. As to what happens. And then we had the business of Charlie Elphick, a Conservative Member of Parliament who sued the Sunday Times, he eventually withdrew a 4-year libel case against the Sunday Times because of articles that were written about sexual assaults. And he hired Carter Ruck, the very well-known libel lawyers, to sue the Sunday Times for libel, and the burden fell on the Sunday Times. And this is one of the important things about the law here, is that the Sunday Times had to defend its decision to publish, rather than Elphick having to show that he hadn't done what they claimed that he'd done. There's no public interest defence there. You know, the newspaper can't sort of say, we wrote this, and then the other person have to prove that it wasn't true. The newspaper spent countless hours and £500,000 defending itself. And so, of course, it has a chilling effect on everybody else when we know that that's what happens. And other media outlets like the BBC were, you know, they all had worries about what the implications of this would be. And, of course, Elphick's sexual assault victims had to relive their trauma, providing more detailed accounts to different organisations and already in and above the ones that they'd given to the police. Examples outside of the UK are multiple. In 2018, the Indian journalist Priya Ramani exposed the alleged sexual harassment of a Minister of State, MJ Akbar, and it led to 13 other women sharing their sexual harassment experiences at the hands of the same man. And in response, Mr. Akbar's lawyers filed a defamation case against Ramani and also sought her prosecution under the penal provision of defamation. And it's a penal, it's a criminal defamation. It used to exist in English law, but we've done away with it. But it still exists in places which we colonised. So criminal defamation still exists in many places. And the Akbar lawsuit, I mean, there was a team of nearly 100 lawyers working on his side and one individual. And it just shows you what it's like to be the target of this kind of thing. And indeed, we've had contact with Priya Ramani and she has been suffering intimidation in an incredible way. Now, Elphick, as you know, he finally dropped his lawsuit earlier this year and is, I think, departing politics, or may have already departed politics, I think. And Gabriel specialises in investigative journalism, and he's covered all of that. And he's also covered, politics and royalty. Both subjects were aggressive and well remunerated lawyers, what's called white shoe lawyers. We don't wear white shoes, And you'll notice I've only got one necklace. Have you seen the photograph that there was of me? I suddenly said it's the same necklace that I had the last time. Anyway, I'm a poor thing. So Gabriel has written a book about Corbyn's Labour Party, but he's also covered US politics in the Washington Post and so on, and you'll be hearing from him shortly. But I just wanted to really remark to you on the way in which my own experience in recent times covered a woman, Caitlin McNamara, who went public about what happened to her at the hands of one of the Emirates royals, who was supposed to be a minister of state, and while she was expecting to be going to a formal meeting about the business that she was there for, cultural events and so on that were being created, she was sexually assaulted by him. And one one of the problems that there is in law is that, I mean, at the time we tried to get lawyers in the Emirates to take up her case. 16 law firms turned us down. And the reason they turned us down is because they're all terrified of taking on the royal family. And if people have enough power, it's even hard to get lawyers to act on behalf of victims in certain places in the world. And so the powerful can get away with things. And there's no doubt, I mean, I tried to persuade the Crown Prosecution Service here in the United Kingdom to use universal jurisdiction, to say that this what happened to her, because the sexual assault was a sort of protracted thing over about 4 hours, where she was being waylaid by him and abused by him, and she was in terror and she spent her time talking to him and trying to talk him down and trying to think of ways of getting away from him, in a place where there was nobody who could protect her apart from his own amanuensis in the household somewhere, and it was far away from anywhere. So we tried to argue that there should be that universal jurisdiction could be used and he could be prosecuted here because he's a man who's got links here. And there was a deep, basically ultimately a refusal to, and a reasoned explanation of why that couldn't happen. And it does seem to me that we should be looking for ways in which some of these people who can skip jurisdiction in order to avoid the consequences of their actions should be possible. But to go back to the business of SLAP, women are never have an easy time in the defamation courts, in the libel courts, and almost invariably the same thing happens there as happens in other parts of our legal system, which is to find ways of denigrating women, find ways of cross-examining women so that they are they lose the trust of the court, or they are undermined in the eyes of the court on matters that are often irrelevant and distant from the reality of the issues before the court. And so women can be particularly vulnerable to that. And I've watched it happening, and I've actually watched it happening in the libel courts. So I do think that the time has come that we have to put our energies behind having legislation here in the United Kingdom, anti-SLAP legislation, and get our energies behind this new law being introduced as soon as possible. So I'm going to pass over to others, and it's really so important that we're here together to discuss these things, because this is one of the ways in which we have a society that is unequal, in which kleptocrats, the rich, oligarchs, but also powerful men who abuse people, who abuse the democratic system, who abuse individuals, who bully, can get away with it because the system is so skewed against anybody who does not have resource. And you heard yesterday from Keelan Gallagher, who was talking about that one of the main reasons why so many cave in so early in litigation of this kind is because they don't have deep pockets, and that we have to have a greater access to legal aid for defamation cases and for defamation defendants. And you heard, I think, also from Mark Stevens talking about the ways in which he argues that SLAP cases were absolutely in the public interest, and that we have to have a public interest defence. So those are the points that I wanted to make. And we've even got David Davis on our side on this, so it's not just one side of the House where there is support for this. We can really get some legislation through, and I hope we will do soon. Over to both of you. And is my colleague going to come online to chair this? Is Heather going to do that? Great. So thank you all. I'm really glad to have been invited to join you today. Thank you.